I'm very much interested in this bill. Comrades, I am speaking from the point that in the history of this country, there has been a lot of instability causing infiltration of small arms in community. To begin with, all overthrows of governments in this country took guns to the community. The first one, the coup of 1971, the government that came with their guns. The one that went with the guns to the community. Likewise, 1985, every government who goes out of power goes with the guns and dumps them in the community. Which means of all these coups, there have been a lot of harms being deposited in community. Comrade, there is need to make people fear these guns. There's a greater need to make people fear to use these guns anyhow. No matter I'm here, first and foremost, being from Karamoja, where there are illegal guns, there are guns in the hands of people who are neither soldiers, you don't understand them, but they are armed to the teeth. I could be the one opposing this bill, but I've come here to support the bill, to say, no, look, some of these people must be dealt with. I want to give an example in my constituency. In the last 6 years, people who have been killed with the people who have guns, who are not soldiers, are 3,985. 3,985 people, we have lost them. Police, the best they can do is to do post-mortem report. So far, we have a police station where there's a room full of post-mortem reports only for 3,980. Not even one person has been prosecuted. There could be challenges in any law. As we talk, comrade, we could be having other, people have a lot of views. There could be flaws, there could be others. But in particular, these laws are very, very vital. For example, to answer the Karamoja question, so far stability is there in Karamoja because through the court martial, most of the criminals are in prisons, which has now been done under the normal law. So I would think that, comrade, in good spirit, in order for peace to be in this country, and for some time, unforeseeable, we are not saying the law will be there forever. If this country improves, we shall keep on reviewing this law. But where we are operating currently, ladies and gentlemen, like us from Karamoja, we need to think about us. As we look here, this country are different. Karamoja is a different question. Without the court martial, there could be a different story now in Karamoja. But because of the action that the army took using the court martial, we are seeing peace. We are about to join development. We are about to join the rest of this country in contributing for progress in this country. So I would know people have different reservations about the law. Let us look at how to handle the excesses if at all they are there. But the law in principle is, we need it at this point in time. So Mr. Chair, I am here submitted that. For me, I think I'm comfortable on the special circumstances in my legal mind. The special circumstances are very critical in ensuring we govern. Because if we allow people to even to manipulate UPDF, if we allow people to manipulate UPDF to their will and they walk away, this is dangerous. It's good we put them in the hook so that everybody fears to go near the gun. Because the gun has been misused in this country. Some of these laws are based on our history as a country. So, Mr. Chair, I strongly support that we committee recommend this law to Parliament. We put this law in place, such that the army are governed. These soldiers, comrades, look at them also. We need to govern them. Otherwise, comrades, things can be a bit very difficult. Even in election, they can manipulate elections and lose elections. So we better have the court martial to keep them at bay. Otherwise, I first end there, Mr. Chair.
The 7 justices of the Supreme Court in their decision found that Section 1171G and H of the Act that provides for trial of civilians in courts martial were unconstitutional due to vagueness. Further, 6 justices noted that for a civilian to be tried in the courts martial, there needs to be in place clear exceptional circumstances. In light of the above, Clause 30 of the bill seeks to prescribe exceptional circumstances by inserting Section 117A. The exceptional circumstances include 1. Where a person voluntarily accompanies any unit or other element of the defense forces which is in active service in any place. 2. Where the person while serving with the defense forces under engagement by which he or she has agreed to be subject of military law. C. Where the person is in unlawful possession of arms, ammunition, or equipment ordinarily being the monopoly of the defense forces as prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of the bill, and commits an offense under any written law. D, where the person aids and abets a person subject to military law in the commission of or conspires with a person subject to military law to commit murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling. E, where the person without authority is found in possession of, sells or wears a uniform, the correction there should be SELLS, sells or wears a uniform of the Defense Forces. F, where a person is found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the Defense Forces prescribed in Schedule 7A of the Act and classified stores in Schedule B of the Act. Where a person is serving in the position of an officer or militant of any force raised and maintained outside and commanded by an officer of the Defense Forces. Honorable Chair and colleagues, the bill under Clause 45, insertions of Section 202A, 202B, 202C, and 202D, seeks to reinforce the independence of the courts martial and the Defense Forces. Sections 202A, which is proposed to be included, provides for the members of the court martial to take the judicial oath. 202B provides for the establishment of military courts department, which shall be responsible for the administration of justice within the Defense Forces and provides for its membership. 202C provides that members of the courts martial shall, in the performance of judicial functions, be independent and impartial and shall not be subject to command. And 202D provides for the establishment of a disciplinary committee for members of the courts martial. The committee shall be established by the High Command in consultation with the Judicial Service Commission. It is important to note that in order to provide for independence of the members of the courts martial, the bill proposes A, to have the members of the General Court Martial appointed by the High Command from a list approved by the High Command in consultation with the Judicial Service Commission, and to have the chairperson of the unit's court martial and the division court martial appointed by the High Command in consultation with the Judicial Service Commission. Stakeholder engagement. The Ministry of Justice and Constitutional Affairs drafted the Uganda People's Forces Amendment Bill in consultation with the Ministry of Defense and Veteran Affairs in accordance with the instructions received from the Ministry of Defense and Veterans Affairs and the approval of Cabinet. Regional and international alignment. It is worth noting that sections 38, 39, clauses 38, 39, and 40 of the proposed bill, which provide for the deployment of troops outside Uganda, provide for the Uganda People's Forces international and regional security commitments adequately. The provisions have not been amended in this bill. Honorable Chairperson, honorable members, I beg to submit. I thank you.
The Supreme Court ruling. And then there was an option on exception of the civilians being charged in the military court. Mr. Chair, you ably communicated that the concerns of the public, save for all the rest of the good about the bill, the issue of civilian. In my line of work as a spokesperson, and sometimes I want to speak from the center of knowledge and understanding, somebody will pop a question. Now, when you look at the categories of people, you say aid, how do you get the certification that this person is aiding? And then we have murder, aggravated robbery, kidnap, but we have competent courts as well. This morning, I was having a discussion with someone, and he asked me, look here, we had a rebel leader, General, I don't know the rank, whether he was entitled to any rank, Jamil Mukulu. And we have this court, the Criminal Division Court. And this man was never subjected to the General Court Martial. But you're saying where we have courts, civilian courts, that are trying people of murder, aggravated robbery, but now you're saying they should. why don't we look at strongly empowering these courts? Because, Mr. Chair, the bill is extremely beautiful. And if this bill was speaking to a young girl, the girl would only accept to go for marriage. But there is that hiccup that we need this legal mind. How do you justify? But we still have these courts. Are we now disempowering the civilian courts? Are we really looking at that only clause to justify that the civilians? I was talking to Jonathan here. We know some people hold guns, lawfully trained, private firearms. But then how would that justification be? So, Bwana Attorney General, we need really to know so that we really speak to this. We need peace, we need to be protected, we appreciate, but we still have courts that are really competent enough to handle this. As we do, let us reflect onto that. Thank you, Mr. Chair.
Member for Ruteno.
Draft as far as the provisions for restructuring the army, for improving the welfare of the officers and the militants, for decentralizing the pension authority, enhancing the compensation and fair payment in case of injuries, and to, I think, those ones, which I think goes a long way in addressing the concerns that existed within the country and complaints that come from the army. I am particularly interested in how the gaps in the payment, the salary structures will be addressed, which is one of the concerns raised here. Mr. Chairman, I have a number of concerns. The first is that one of the justifications for this bill is stated to be to align the Act, the UPDF Act, with the decision of the Supreme Court. My question is, what was the issue before the Supreme Court and what was the decision? Which I will also attempt to answer. The question was, is it lawful? Is it legal? Is it constitutional to try a civilian in the military justice system or military court? That was the only question that went to the Supreme Court. And the answer was, it is unconstitutional, it is illegal. I want the movers to show me in this bill how you have complied with the decision. There was one decision that it is unconstitutional. Do not try civilians before the court martial. I want to find out where in this bill you have aligned that question, which was answered by majority unanimously, so that I can trace it. So far, I have failed to see it. The movers seem to have gone and created his own judgment, his own decision, his own orders, and then it is being used here. I would be very happy if that is pointed to me. And I could have even stopped at only that. But let me go to the others to help me.